The judge owned stock in the company he was ruling on. He refused to step aside. And what happened next exposed a crisis rotting American justice from the inside. In 2021, a federal judge in Texas ruled on a case worth $14 billion. The losing party later discovered something troubling. The judge owned stock in the winning company. When they demanded he step aside, he refused. Said his investment was too small to matter. But here's what makes this case extraordinary. It wasn't an isolated incident. An investigation by the Wall Street Journal found that over 130 federal judges had violated ethics laws by ruling on cases involving companies they personally invested in. 130 judges. Exposed. And yet, almost none faced consequences. How did we get here? And why does the system protect judges who refuse to recuse themselves even when the evidence of conflict is undeniable? Let me put this in perspective. If you walked into a courtroom and your judge had dinner last week with the person suing you, you'd expect them to step aside. That's common sense. But the rules governing judicial recusal are shockingly weak. Under federal law, judges must disqualify themselves when their impartiality might reasonably be questioned. Sounds simple, right? But there's a catch. In most cases, the judge decides whether they should recuse themselves. Think about that. The person accused of bias gets to determine if they're actually biased. And appeals courts almost never overturn these decisions. They call it judicial discretion. Critics call it something else entirely. A system designed to protect judges, not justice. If this is already making you question everything, drop a like so I know to keep digging. Now imagine you're the defendant in this situation. In 2019, a man named Mark faced a civil lawsuit in state court. During discovery, his attorney uncovered that the presiding judge had previously represented the plaintiff's company as a private attorney. 10 years earlier, but still. They filed a recusal motion. Denied. The judge said too much time had passed. Mark lost the case. Lost his business. Lost his home. He appealed, arguing the judge's refusal to recuse violated his right to a fair trial. The appeals court acknowledged the conflict looked bad. But they ruled the original judge hadn't abused his discretion. Discretion. That word again. Mark spent 3 years and $200,000 fighting for a new trial. He never got one. But here's where it gets even more disturbing. The Supreme Court is supposed to be the guardian of judicial ethics. The highest court in the land. Beyond reproach. But in 2023, investigative journalists exposed something that shattered that image. Justice Clarence Thomas had accepted luxury vacations worth millions from a billionaire political donor. Private jet flights. Yacht trips. A real estate deal involving Thomas's mother. For years, Thomas failed to disclose these gifts as required by law. When confronted, defenders argued Supreme Court justices aren't bound by the same ethics rules as lower court judges. That's technically true. The Supreme Court had no binding ethics code. Think about that. The 9 most powerful judges in America operated under looser ethics rules than a small claims court magistrate. And Justice Thomas? He participated in cases where his benefactor had clear interests at stake. But that's not even the worst part. What I'm about to tell you reveals why this crisis threatens every American who might ever face a courtroom. In 2022, researchers at Duke University created a database tracking judicial recusal decisions. What they found was staggering. In cases involving campaign donors, judges ruled in favor of their donors 68% of the time. 68%. In cases where judges owned stock in a party, they ruled for that party 71% of the time. This isn't speculation. This is data. The system isn't just broken. It's rigged in plain sight. And the people suffering most aren't wealthy corporations who can appeal. It's ordinary Americans who can't afford to fight back. If you want to see how deep this rabbit hole goes, make sure you're subscribed. Because the solution being proposed might be even more shocking than the problem. So what happens when someone actually fights back? In 2018, a class action lawsuit challenged a judge in West Virginia who refused to recuse despite owning substantial stock in a coal company he was presiding over. The case went all the way to the Supreme Court. And in a rare unanimous decision, the justices ruled the judge should have stepped aside. But pay attention to what happened next. The judge faced no discipline. No removal. No consequences whatsoever. He simply stopped hearing that particular case and continued his career. The plaintiffs got a new trial after years of fighting. The judge got to keep his bench. Tell me in the comments. Does that sound like accountability to you? Because what the legal establishment proposed as a solution will make your jaw drop. In 2023, under immense public pressure, the Supreme Court adopted its first ever ethics code. Finally, accountability, right? Read the fine print. The code has no enforcement mechanism. No penalties for violations. Justices police themselves. The very problem that created this crisis is baked into the solution. But here's what you need to understand. Congress has the power to change this. The Constitution gives Congress authority to regulate federal courts. Bills have been introduced requiring mandatory recusal in cases of financial conflict. Creating independent ethics enforcement for the Supreme Court. Establishing a public database of all judicial investments. These bills exist. They have bipartisan support. Yet they sit stalled in committee. The question isn't whether reform is possible. It's whether those in power want the system to change at all. Every year,